farmer filing Chapter 12 bankruptcy has the ability to deprioritize taxes incurred on the sale of assets that were used in farming. However, producers often look for guidance on how to prioritize provisions and how that applies to taxes that have already been paid. Roger McEowen with the Washburn University School of Law joins us now for today's Rural Money segment. Thanks for joining us, Roger. Let's start with some background on the 2005 modified tax provision.
Well, good to be with you, Christina. Chapter 12 bankruptcy, if we go back in time, it originated in 1986 at the height of the farm debt crisis that was occurring at that time. And one of the problems was that there was no separate tax-paying entity from the debtor. And so when a farmer would try to downsize, to sell off some assets, to pay off some creditors, to stave off filing bankruptcy, they would trigger taxes in doing so and perhaps recapture taxes also, but a lot of capital gain in particular. Well, the IRS would sit there and State Department of Revenue would be there, and they would get paid first. They had a priority claim. And that often caused farmers, as a result of the 80s debt crisis and those that were filing bankruptcy in the 90s, to be unable to pay that tax debt in order to put together a reorganization plan. So then they would have to file a liquidation bankruptcy, which defeated the whole purpose of the law. So in 2005, Congress changed that and basically said, if you triggered taxes upon the sale of assets used in farming, we're going to move that tax liability to the back of the line, and we're going to treat those as other unsecured creditors. So you don't have to pay the taxes up front first.
You know, Roger, I hate the fact that we're even talking about bankruptcy, but we do want to make sure that everybody out there is as prepared and equipped as possible for what's happening right now. Talk about the methods of computation that we really have to consider here.
Well, Congress, when they changed the law, they didn't tell us how the deprioritization is to be computed. You know, what portion of the tax liability is deprioritized and moved to the back of the line. IRS came up with its own approach, known as the proportional method. Individual farmers came up with their approach, known as the marginal approach. Basically, the IRS approach was more favorable to them. That meant that less taxes would be deprioritized. And largely the courts, however, have followed the marginal approach, which is the farm debtors approach. So there are two approaches, and they involve different steps. But farmers have largely come out ahead so far on that.
Happy to hear that. What's the big takeaway here?
Well, the big takeaway, and with a couple of recent court developments just last week dealing with withheld taxes, taxes that have already been paid, do those get pulled back into the computation and become deprioritized? An Iowa court case said yes, an Indiana court case said no, so we're still dealing with that issue. But I think the real big takeaway is that if you're thinking of filing Chapter 12 bankruptcy, even the thought of it, get competent bankruptcy and tax counsel. Your bankruptcy attorney can't handle this if they don't have good tax background. Tax attorney can't handle this if they don't have a good bankruptcy background in handling Chapter 12. You have to have both. Definitely don't try to do it by yourself.
No, and you know, sometimes it's just what makes the most sense, but you got to find out if that's the case. So you want to go to the expert, just like Roger said. Thank you so much. Roger McEowen with the Washburn University School of Law. Really appreciate you. And looking forward to having more conversations. We're going to see a lot of lawsuits come out of what's happening right now. Stick with us.